9:05. We do have 17 people in the training this morning. Just want to say good morning to everyone and welcome to the Arizona Public Records Law Training. I am Natasha Kennedy and I am the clerk of the board here at Pinal County. And I just want to say thank you to all of our attendees for attending training today. We do have attendees, of course, from Pinal County. We do also have other attendees from other counties, and we have attendees from the Arizona County Clerks Association as well. I'm going to go over just a couple of reminders this morning. Just a reminder that this is an interactive training. We're going to be utilizing the chat tool, which is at the top right-hand corner of your monitor. I am going to be providing questions, and the attendees will have about 10 minutes to answer those questions. In order to receive your certificate of completion, you do have to answer those questions within the time limit of those 10 minutes. And you also have to make sure that you complete your ideas to action, and that is due by August the 11th. And also, we're going to have a bio introduction for our instructor today by our deputy clerk here at Pinal County, which is Kelsey Picker. Kelsey?
Good morning. Danny Gueron is a staff attorney for the Ombudsman's Office and specializes in open meeting and public record law matters. He joined the Ombudsman's Office in 2014. Danny has a Juris Doctor degree from the Sandra Day O'Connor School of Law at Arizona State University and is a licensed attorney. And I'll go ahead and let Danny take it away from here.
Good morning, everybody. My name is Danny Gueron. I am with the Arizona Ombudsman's Office. Just real quick before we dive into the public records law, I want to briefly explain what our office is and what we do. We are a legislative agency, so we're part of the legislature. We're independent from the governor, independent from the Attorney General's office. Our main function is to take and investigate complaints we receive from the public about Arizona state agencies. But when it comes to public records and open meeting law, our investigative authority extends down to the local level as well. So to the counties, municipalities, school districts, special taxing districts. Part of our legal responsibility when it comes to those two areas of law is to also prepare materials and to educate the public and public officials. So that's why I'm doing this training today. Our office offers open meeting law and public records law booklets. They're available on our website, but if you want any hard copies, you can email me or give our office a call. We can send you some. I suggest at least bookmarking the online PDF because it contains all the relevant laws on that subject. It contains the Attorney General's chapter on that subject and a whole bunch of other useful materials. It covers 90 to 98% of what you'll ever need when referring to the open meeting and public records law. So what is the public records law? It's mostly laid out in Title 39, Section 121 and 121.01. But there are some additional statutes through 161 that touch on various issues related to it. But the real meat of it, the real crux of what it is, are in those first two. And basically, the takeaway from the public records law is that all public records and other matters in the custody of a public official or a public body need to be promptly made available to any person who wants to look at them or to copy them. So basically, if government has records, it's presumed that the public gets to look at and copy them in a reasonable time frame. That's the basic framework from which everything else is going to flow. So what's the public policy sort of undergirding all of this? What's the rationale? Basically, again, we're government. We all work for the people. So the legislature has decided the people get to see what we're doing so they can decide if we're doing it well and decide if they want other people to be doing it instead. It holds us accountable. It lets the public evaluate what we're doing, so on and so forth. That's the basic framework, is transparency in government. It's just, the public records law is a sunshine law, if you've ever heard of that. So who's covered? If you were present for my open meeting law presentation last week, this term should sound familiar. Public bodies. However, under the public records law, public bodies have a slightly different definition. Basically, it comes down to whether you're governmental, or at least you're a public organization that gets money or expends money directly from the state or subdivisions of the state. So even if you're not 100% traditionally governmental, if you're governmental in nature and your money directly comes from taxpayers, then you're probably a public body subject to the public records law. Similar to when I mentioned it in the context of the open meeting law, there's an attorney general opinion from 2007 that gives some guidance on how to figure out on some of those weirder cases or tougher cases whether the entity at issue is a public body subject to the public records law. But when you work for the county, everything you touch, everything all your coworkers and colleagues touch, that's governmental. That's going to be subject to the public records law. I'll touch on this slide again later once I've provided more context, but this is probably the most important thing I'm going to show you today. This is the basic structure for how you should handle a public records request when it comes into you, or if you're making a public records request, how it's going to be analyzed and handled. So it's really a two-step analysis. The first is the record that's being requested or the records, are they public records or other matters as referred to in the public records law? If not, you're done. If it's not a public record, it's not subject to the public records law. You don't need to provide it. The public records law doesn't apply. If it is a public record or other matter, it's presumed to be subject to disclosure. That's the default in the public records law. Public records are default open to the public. So if it's a public record, we move to step 2. Does anything overcome that presumption? Do any of the 3 types of exceptions to disclosure apply? If they do, you don't have to give out the record. If they don't, you got to provide the record. So step 1, is it a public record? If no, you're done. If yes, does an exception apply? If so, don't give it out. If not, give it out. It's very straightforward, but of course the details on how to actually evaluate these 2 items will be a little bit more complicated, and we'll get into that. So what exactly is a public record? The courts, well, I'll back up. It might surprise you, it might not, depending on how long you've been in government, but the Arizona legislature did not put a definition of public record in the public records law. That seems strange, but I think if you really think about it, it makes sense, because as anyone who's ever read the laws or had to interpret laws knows, it's hard to write laws that cover every eventuality. Even if you spent hours and hours and years of experience on it, eventually something will come up that's not addressed by the law you wrote. So I think the legislature probably left it vague intentionally. So the courts over decades have filled in and said, through various court cases, here's how you determine whether something is a public record. And originally the court said if it's a record made in pursuance of a duty, or if it's required by law to be maintained, or if it's a record of official government transactions, it's a public record. So everything created or received by a public body or public officer that relates to public business. That was the general understanding that the courts gradually came to. Even though public records is not defined in the public records law, it does include by specific reference records as defined in this statute in 41-151.18. And that definition basically covers physical materials. So it says records are all books, papers, blah, 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 regardless of physical form or characteristics, were made or received by the government. So it doesn't matter if it's electronic, if it's print, if it's some sort of other weird media, it can be a record, and then therefore it can be a public record. So all of these types of different media and materials are incorporated into the public records law. So if you ever find yourself saying, well, that's not a record because it's in this form, you're probably wrong. The form really doesn't matter. If you can preserve some sort of human knowledge, if you can write stuff down or record stuff, or it's a photo of something, or if it's a map of something, then it's a record, and it can be a public record depending on the content. As I said, that includes electronic records. I think the more and more familiar we all are with computers and computer technology, the more common sense or accustomed we are to this. But just in case, that can include web pages, Word documents, word processing files, databases, electronic communication, so emails, Twitter things, Instagram, Snapchat, TikTok videos, anything like that can be a public record. Metadata, social networking stuff. What is metadata? Metadata is data that exists in records, electronic records, that you might not realize is there. Every time you create a Word document, you're familiar with, you create the title, and whatever you type down in the main document is part of the record. What you might not realize is Microsoft Word or whatever program you're using creates some additional data that you might not readily see, such as who created it, when it was created, maybe when it was edited, what account it was created with. Again, that stuff's not usually in front of your eyes, but it is part of the file, and arguably is part of the record. And that's not just for Word documents. You see the same thing with PDFs and databases. There's all sorts of interesting stuff that can be saved as part of the record or the document without you realizing it. So is that part of the record and subject to the public records law? According to the Arizona Supreme Court, it is. This was a case where a Phoenix police officer seemed to think that the city of Phoenix was altering records he had requested. So he requested the records in their original electronic format. The city said, no, absolutely not. We're not giving you the metadata. We don't have to give you that stuff that would show whether the records had been altered. So he sued. Went to the Arizona Supreme Court, and which overturned some of what the Court of Appeals said. And the Arizona Supreme Court basically said any embedded metadata in a record is part of the record, and the public's entitled to it. And they also said that if you keep a record in electronic format, if that's how your agency maintains it, then the public is entitled to see that record in its native electronic format. So if you keep official records in Word document, Microsoft Word document format on your computers, and somebody requests it, you probably can't print it out or give it to them in a PDF. If the person wants that original format, you probably have to provide it to them, according to this Arizona Supreme Court case. Interestingly, the court also said unfinished police reports are public records subject to disclosure, unless an exception applies, which to me implies that there's no exception in Arizona law for drafts. Just because something's unfinished or in a draft format doesn't make it special under the public records law. You might be able to make an argument under one of the recognized exceptions for why you don't have to give it out, but it is a public record presumed to be subject to disclosure. That's something you need to keep in mind going forward. ARS 39-121 specifically requires public bodies to maintain disciplinary records for employees, and that they're open to inspection and copying unless there's a specific statute that says otherwise. This shouldn't surprise people, but it does sometimes. As government employees, we work for the public, and if we're being disciplined and doing stuff wrong, that is of strong interest of the public. We don't really have a lot of privacy as government employees in what we're doing in our employment. So if you do a bunch of stuff wrong that gets put in your personnel folder, then the public's probably going to be able to see most of that. So keep that in mind with how you behave. I mentioned earlier that the public records law applies to public records and other matters. What is an other matter? I have no idea. As I said, the legislature never bothered to talk to us about what any of this means. For decades, the courts in Arizona kind of wrestled over this, and they used to try to have some idea of what the difference was between a public record and an other matter. Originally, it was things that are required by law to be, or not required by law to be kept by government, but still are held in official capacity. So they were public in nature, but there was nothing specifically in law that said you have to make and hold on to these. But over time, the courts have basically annihilated any distinction between other matters and public records. You pretty much will never hear the term other matters. Everything's just referred to as public records now. And the courts have basically come up with one test for determining whether something is a public record. So even though this language is in the statute and it used to sort of have some sort of role to play, it doesn't anymore. I'm just telling you this to give you the full context of how it's worked out. But regardless of whether it would be a public record or an other matter, it was still treated exactly the same. And now, since the courts in the last 10, 15 years have sort of gotten rid of the idea that other matters are separate, there's no reason to really commit this to your memory going forward. Just in case anyone ever brings it up or you read the public records law, this is the context. What are some examples of things that might be public records or other matters that you might not have thought of or might not have occurred to you? Calendars. If you have a calendar on your computer, either through, say, you use G Suite with Google, or you're using Microsoft and your email application has a calendar. Those calendars are public records when they relate to your business as an employee of the government. Any reports, brief, legal memos, maps, policies and procedures, photos, personnel records, case files, emails, salaries of employees, agendas, minutes, exhibits, budgets, annual reports, anything official travel related, any official phone records, police reports, any stuff like that. So just about anything that is done at your office, regardless of whether it's related to your main function or it's a side thing like salaries and HR records, those are all public records. What's not a public record? If you have just extra copies, if you have 1,000 blank copies of a form, not all 1,000 of those are public records. No one's entitled to come in and look at every copy of the record in your building. If you just put a Post-it note on your computer screen that says, hey, remember to do this by 4, that's probably not a public record. It's probably more of a personal note. Commercially available software. So if you have the Microsoft Office suite on your computer, people don't get to public records request that and get a copy for free. Similar idea with other commercially available materials. So if you have a set of encyclopedias or statute books, no one's entitled to come in and do their legal research in your office just because you have those in your office. And then most importantly, private things, private papers, private documents. So anything purely personal is not a public record. And now I'm going to jump into that. So this case is huge. You don't need to remember the case, but you need to remember what comes out of it. Griffiths v. Pinal County was in 2007, and this is the case that really modernized, in my opinion, most of the public records law. This is where the court basically said, forget about public records versus other matters, and here's the main test for how you determine if something's a public record. So that everyone who receives public records requests in the state, this is the analysis you should be applying. And the takeaway was, it's the nature and purpose of the record that determines its status, not its location, not whether it was made or government property was used in making it. So it's just what's in the record that determines whether it's a public record. So if it's purely personal, no matter whether it was created on government equipment or with government accounts, if it's purely personal, it is not a public record. It is not subject to the public records law. So if I use my .gov email address and my work laptop, and I email my wife, hey, what do you want me to pick up from the store on the way home for dinner? That, even though I used government equipment and government accounts, that's not a public record because it's purely personal. So what happens if somebody's suing over a public records request and the issue is whether the document is a public record or private in nature? How does the court look at that? Well, the court will look at it in camera, which basically is Latin lawyer speak for in private. So if the court then concludes it's not a public record, it hasn't been made part of the court record and disclosed to the public improperly. So just because you do something private on a government computer doesn't necessarily mean it'll be revealed if you get sued over whether that record needs to be revealed to the public. So everything was great after that court case. For years, it seemed like just about everybody agreed after reading it that the test is whether it has a substantial nexus to government activity. Is it government-centered in its content? If so, it is a public record, regardless of whether it was on a government computer or a private computer. Then in 2017, the Attorney General just rolled a landmine in the middle of, or a hand grenade in the middle of everybody and made it all complicated. They issued a formal legal opinion where they basically said messages sent and received, either texting or social media by public officials, are not necessarily public records if they're created on a private device or private account. That I don't know where the Attorney General really got that from. It sort of came out of left field. The idea behind their conclusion seemed to be that court case, Griffiths v. Pinal County, was only addressing public record or private matters on government equipment. It didn't do the inverse. It didn't address government-related records on private devices and private equipment. Therefore, we can't read more into the public records law and say that those are public records. So basically, if you were a detractor of this opinion, if you viewed it negatively, you would probably conclude that if a government official wanted to dodge public accountability, all they had to do was use their private phone or their private email addresses. And then no matter what the records they were sending or creating were about, they weren't subject to disclosure under the public records law. That was really the big implication of this Attorney General opinion. Fortunately, that didn't last long. There's a court case that comes out a few months later that, without specifically addressing this AG opinion, basically threw it in the garbage. I'll get to that in a moment, but just to further, I guess, analyze that AG opinion. Even though the AG said if it's public in nature, but it's on private equipment, it's not a public record subject to disclosure, they still said, the AG still concluded that you have some sort of obligation to record or maintain those records. What that meant or where they got that from wasn't clear. Doesn't make a lot of sense in my opinion, but that's what they said. So the public doesn't get to see them if they're on private devices, but they're still related to public duties and need to be maintained in some way. So the AG concluded if it's on government equipment, you apply the Griffiths test. Is it personal or does it have a substantial nexus to government activity? But if it's on a private device, regardless of the content, it's not going to be a public record subject to disclosure under the public records law. Everybody who, in my opinion, was very knowledgeable about the public records law was very troubled by this. But as I said, a few months later, the Court of Appeal sort of straightened it out. It was a court case where somebody sued the government because they wanted law enforcement phone records. There was a police officer or several police officers who the requester thought had been using their private phones to conduct their work. They would show up to the scene of an accident, use their private cell phone for some reason to call dispatch or whatever. So they were creating public records on their private devices. The court said, doesn't matter. They basically extended the Griffiths test to cover the situation where it's a private device or a private account. So they basically said the direct opposite of what the Attorney General's office said. If there's a substantial question about whether the subject is a public record and government related, then the court will look at it and can determine it's a public record. And they looked at this case where it was a government employee using their private phone for government activity and said, that can definitely qualify. And you've shown, the police officers admitted they've done it. Therefore, you've shown enough that we can look at those records and determine whether they're a public record. So basically going forward, you need, in these situations, the requester needs to be able to show some evidence that the person used their private device or their private account to create public records, to do government activity. If they're able to do that, then the government basically has to show that it's not government related. So the burden shifts to the government. So you have a very low, as a requester, you have a very low hurdle to clear. Basically, if you could show any reason to believe, any good reason, credible reason that the person's private account or private device was used to do government work, then the government basically has to rebut that and say, but there were no government records created on it. So all of that is complicated, and I'm probably making your eyes glaze over because this is not the most exciting thing in the world. So what's the takeaway? After this court case, the previous one, and the Attorney General opinion, here's what the law is. If there's a substantial nexus to government activity, the record is a public record subject to the public records law. It does not matter if it was created or received on a government device or a government account. If it was on a private device or a private account, it can still be a public record. If it's purely personal in nature, despite what the device or account was that was used to make it, it's not a public record. So the big takeaway is the content of the record. Does it have a substantial nexus to government activity? If yes, public record. So all that hullabaloo was just to arrive at that. And that's, in my opinion, pretty straightforward, and that's where the law stands. So I'm going to quickly shift gears a little bit to records management. I'm not a records management expert. I have a decent understanding of it, but if you really want to dive into the specifics and the minutiae of this, the people to talk to work for the Secretary of State's office in a division called Library, Archives, and Public Records. These are the people who decide for the state, all the government in the state, here are the records you need to keep, here's how long you need to keep them, and here's how we recommend you keep them. So what sort of responsibilities do you have when it comes to records management? Well, you need to make and maintain records. You need to have a records management program. You need to then follow that program to preserve the records. You need to adhere to the retention schedules issued by Arizona Library, Archives, and Public Records. And then at the end of the retention period, you need to destroy the records. That is how you're supposed to manage your records in the state of Arizona. So first, in the public records law itself, in 39-121-01, the public records law says public officers and bodies shall maintain all records reasonably and appropriate to maintain an accurate knowledge of their official activities and activities that are supported by government money. So what you and your agency are doing, there should be a record of. The Supreme Court says you have a duty to make records, but it hasn't really gone into a lot of detail, leaving that a little vague to be hammered out, I guess, by future courts and by the Secretary of State's office. But generally, you should be making records of what you're doing in your official jobs. You should have, you have a duty, and you should have records that basically indicate how your organization is operated. So if everyone in your organization were to resign at the same time, or all get the coronavirus and be out of commission for a while, someone should be able to go in, look at these records, and understand the organization, function, policies, so on and so forth of your agency, what your agency does and how it does it. Every agency is supposed to have this stuff. There should be a filing cabinet or a server somewhere that has this basic stuff laid out about your agency. You're supposed to have a records management program. You should have something official in place that says, here is how we maintain our records. Here's whose job it is to do A, B, and C. Here's where we send these records. Here's what we do with these records. Here's how we destroy those records. Does everybody have one of these? Is it clear? Is it known to everyone? Probably not. In the last 10, 20 years, with the increase in emails we all send and all the electronic records we send, we create a zillion records every week, every year. And it's become, in my opinion, a little difficult and a little unreasonable to expect everything to run smoothly in records management. And the legislature really hasn't updated the public records law, or in my understanding, really hasn't provided too much more funding to do all of this. So a lot of agencies are doing the best they can. So that's really what you should be aiming for. Come as close as you possibly can to complying with all of this stuff. You have a duty to preserve records from deterioration, mutilation, loss, destruction. So if you're keeping your records in a wet, damp basement in cardboard boxes that are molding and falling apart, you're probably not meeting your responsibilities. As I mentioned, Arizona Library and Archives and Public Records is the entity that does all of this. They train on this, they educate on this. They're the ones who put out the retention schedules that say how long you keep what records for. You can find those retention schedules on their website. They cover just about everything under the sun. If you have records that are unique and not addressed by what Library and Archives' retention schedules say, you have a duty to go to that agency, talk to them, and get a custom retention schedule made for your agency that covers your unique records. So if you look at all the retention schedules and say, boy, oh boy, I don't see records X, Y, and Z on there, what do? You reach out to the agency and hammer it out with them as to how long you need to keep those records for, and they'll put out a custom retention schedule for you. If you're a pretty standard county agency, you're probably not going to have many, if at all, any records that aren't covered by general retention schedules. But if you find something unique that isn't covered, this is what you need to do. If you read the following statute, it kind of makes it sound like you maybe aren't 100% required if you're a county, municipality, or other subdivision of the state by penalty of law to follow what Library and Archives is saying. But it says you should, as best as you can, follow what the state is saying. So I think if you want to be better safe than sorry, follow the state retention schedules. If you don't, and say you don't have to, I wouldn't want to be you when you get brought to court by the Secretary of State's office or a member of the public. Some types of records you might overlook when it comes to retention and maintaining them. Voicemail. If you get some business-related voicemails that are pertinent to something, you don't necessarily need to keep the voicemail, but it should probably be noted somewhere in the relevant records. Same thing with other computerized records. Those need to be maintained and recorded and not just deleted when you're done with them. Same thing with emails and social media. The Arizona Public Records Law was written before email and social media. Therefore, the Public Records Law does not really cleanly address or provide clear answers for how to handle email and social media. So Library and Archives does its best to put out guidelines on how to handle all that. So if you're curious on how to handle all of that, go take a look and consult with the agency. Common question: how long do I have to keep emails for? I have a bad answer for you. Email is not its own retention series. There's not just something from Library and Archives that says keep email for X amount of months or X amount of years. Instead, it depends on what the content of the email is. Is it related to financing or budget? Then you're going to keep it for this long. Does it relate to firing somebody? Then it's going to be kept for this long. Is it about who's bringing what to the potluck at work that day? Then you could probably toss it out when you're done with it, because it's known as a transitory communication, whose value ends when you're done with it. This is, in my opinion, what makes record retention really difficult in the new millennium. We send countless emails, and yet our agencies or our officials are supposed to be cataloging which type of subject it is, and if it's the right type of subject, firing it off somewhere to save it for however many years. Is that practical? Is that even reasonable with our current resources? Honestly, probably not, depending on how many emails your agency sends and receives, but that is the law. So you're supposed to have something in place that determines how your emails are going to be retained when they fit into one of the retention schedules laid out by Library and Archives. So this is probably something that needs to be discussed with all of your employees, because it's really not practical in most situations to have one or two people in your whole agency do this for everybody. When it comes to email, it really makes more sense, in my opinion, to have individuals take care of sorting their own emails out. And of course, that's going to lead to some mistakes. Should not be destroying public records unless authorized by the state of Arizona. When Library and Archives says you can destroy it, you're supposed to destroy it then and in the way they prescribe. So if the director of Library and Archives says it no longer has administrative, legal, fiscal, whatever value, aka it's now outside the relevant retention period, you're supposed to destroy it. Be careful about how you do this. If it has special identifying information about people, such as social security numbers and birthdays and things like that, don't just toss it in a recycling bin in front of your building. It'll allow identity theft to occur. So shred that stuff, get a black marker and redact that stuff, or throw it in a furnace, do something to properly destroy those records so people's IDs don't get stolen. Don't intentionally do bad things to public records you're not supposed to do. If you steal them and hide them and destroy them or falsify them, you're committing a felony. Depending on your position, it could be a worse felony. So either way, you could end up in a lot of trouble. So if there's something embarrassing in a public record and you think the best way to handle that is to alter it or hide it under your bed at home, you're committing a felony. So I highly suggest not doing that. What problems arise when it comes to record retention and record maintenance? Keeping records too long. You won't really get in trouble if you keep records too long. So if you have a retention schedule that says keep these records for 5 years, and it's year 7 and you still have them, no one's going to throw you in jail. You're not really violating the law. You're definitely not committing a crime, but you are going to cause some trouble for yourself that you don't need to cause. What can happen? Well, when somebody makes a public records request to your agency, even though you should have and could have properly destroyed those records, you haven't. So they're still subject to the public records law. So now you have even more records than you needed to that you have to search and look for public records. Alternatively, you could also still be sued and those records be used as evidence. So if your agency gets sued for a record or a subject and you still have the records you should have destroyed, those are now subject to disclosure in the court matter and can be used against your agency. So it subjects the state and the county to legal liability longer than it needs to. So that's the real reason to get rid of these records. Plus, it's just expensive to maintain records. If you have filing cabinets and filing cabinets of records you don't need to have anymore, get rid of them. So it frees up room and you don't have to spend more money and resources on keeping records. Again, if you have any further questions on this, you want assistance on record maintenance and retention, talk to the folks at Library Archives and Public Records. They're kind of short-staffed and there's been a lot of turnover over there, but they're usually very nice people and they're usually really into this stuff. So they should be able to answer. If they can't answer your question on these subjects, then pretty much nobody can. Back to public records requests. Is everybody still doing well? Am I still transmitting to everybody? I'll take that as a yes.
Yes, we're still here.
Great. So if you receive a public records request as a government official, what do? What matters? What doesn't matter? How do you handle it? Well, something to keep in mind is the identity of the requester and the reason they want the records do not matter. That doesn't affect your analysis and how you handle that public records request. Will that always be the case? Will that change in the future? Will the legislature modify the law? I would not be surprised. Before the coronavirus kicked in, there was a bill or two this year that the legislature seemed like they were going to modify the public records law a little bit to make it somewhat harder to get records and to make it a little more, basically make it so that requesters might have to identify themselves and at least give you a little blurb about why they wanted the request. So basically eliminate the ability to do anonymous requests. However, that didn't happen. It didn't pass because the coronavirus short-circuited the whole legislative session. So right now, and the way it's been for a long time, is the person doesn't need to identify themselves, and they don't really have to tell you why they want the record, and why they want it doesn't matter to you. It doesn't affect the analysis of the request. The only exception to that is if they're requesting the record for a commercial purpose, the public records law requires that they reveal that to you and tell you the commercial purpose. But if they say it's for a non-commercial purpose, that's really it. They don't have to tell you much more than that. You can ask them and they can tell you, and it might be in their best interest, just it might help you better figure out what records they're after, but they don't have to reveal any of that to you. Arizona law doesn't require written requests. Again, I wouldn't be surprised if that changes over the next couple of years, depending on who's in power after the next election. Part of that bill I was talking about was going to mandate that you had to put your requests in writing and that you're going to have to reveal yourself. Big changes in the public records law, but again, didn't happen. So right now, if somebody makes a verbal request, if they call your main line and they get a hold of you and say, hey, I want the following records, you can ask that they put their request in writing, but if they say no, you got to handle that request like you would any other. What records are you responsible for when somebody requests records? You're responsible under the public records law for records in your custody, in your agency, or in your personal custody as a government official. What does that mean? You have control over them. They're in your building, they're on your systems, they're in your warehouses, whatever. Even if they originated with another agency. It doesn't have to be a record that started with you. So if you work for the County Board of Supervisors and you have records from the sheriff's office, even though those aren't your agency's records, those are public records in your custody, you'll have to handle a request for them if it comes into your office. Again, doesn't matter where it is. If you store it in a warehouse underground in Area 51, if those are your records and you have control over them, You have to search them and provide records from them if somebody wants to see them. Public records law entitles the public to request that you mail them copies of public records if they're not available on your website. So if somebody asks for a record to be mailed to them and it's on your website, you can just point them to the website. If it's not, then you're going to have to mail the record to them. However, you can request or require that the person pay in advance for the copying and postage charges. So if it's going to cost $50 to make the record copies and to mail them, you can say $50 or we're not doing anything for you. When do you have to provide records? Somebody requests records from your agency. How long do you have to furnish them? The public records law says that you have to promptly furnish copies of public records. As you might have guessed, that's not defined clearly by the Arizona public records law. So the courts have said it depends on what's reasonable under the circumstances. So the particular facts surrounding that request dictate what is prompt in that situation. What I suggest doing is when you receive a request, when your agency receives a request, whoever's good job is to take and handle that request, acknowledge it to the requester. Tell them you got your request or their request and communicate about what to expect. If you don't, if you just start working on it silently, the person's going to continue to bug you. They might complain to my office and say, hey, I haven't heard anything from that agency. And it's just going to cause you trouble. So I suggest telling them you got the request and what to expect and the estimated time frame. Under the public records law, if you do not promptly respond to a request, it's the same as if you denied it, which if it's a public record they're entitled to would be an improper denial. And it would be the same as if you just said, no, you can't have that. So it's going to cause you trouble if you're not prompt. Helpful rule of thumb, I think it's worth keeping in mind as a government official, is about how long would it take you to produce if you wanted it? Well, then that's should be sort of the general guide for providing it to a member of the public. So I said promptness is based on the facts of the situation. What sort of facts? The courts have said it's based on your agency's resources, the nature of the request, the content of the records, and where they are. So if the records are in a vault in the desert, you're going to have longer to search them and disclose them to the public, versus if they're just sitting on your hard drive on your computer. What's the content? Is it stuff that needs to be reviewed and potentially redacted because it contains confidential material? Then what's prompt is going to be a longer period of time. Is the request for one memo that's just sitting on your hard drive, or is it for a million different records that need to be gathered from all over the place? Are you a big agency with lots of resources, or are you a 4-person fire district in the middle of rural Arizona? All of those things will affect what is prompt in a particular scenario. And the courts have said just because it's inconvenient to you to have to deal with this public request, records request, does not make it legitimate to delay the request further. No one's ever gotten a public records request and said, boy, oh boy, how convenient. It's always a pain to deal with, and sometimes it's a huge pain. But you still have to handle it in a prompt, reasonable manner. You will probably notice a trend in the next few slides that a lot of these public records cases that have given us insight into what's required have to do with Sheriff Joe. So we can all thank Sheriff Joe for this clarity we've received on the public records law. His agency was responsible for the big case on what constitutes promptness. That's where the court laid out all those factors and all those measuring sticks I laid out on the previous slide. Basically, the court looked at prompt, looked at a dictionary, and said it's quick to do what is required. Do it once without delay. In this situation, the sheriff's office routinely produced a press release that it would send out to different media outlets. They had one media outlet they just seemed to not like, so they wouldn't produce it at the same time, and they would basically make that other media outlet wait for days, even though they were asking for it. They got sued. Believe it or not, they had no good reason for why they were doing what they were doing, so they got hit hard. The court ruled it wasn't prompt and awarded costs and attorney's fees to the news outlet, which got very expensive for the government. Again, how broad was the request? How many records did it cover? How many people did it cover? So on and so forth. Those are the type of factors that are taken into consideration when deciding what is prompt. The courts have also said that you have to honor ongoing requests or standing requests, whatever somebody refers to it as. So if you have records that you regularly create and somebody says, hey, whenever you create one of those, can you send it to me? You have to honor that request. They don't have to routinely request each subsequent version of that record. So if your agency produces every 2 weeks a newsletter and somebody says, hey, I want to make an ongoing request for that newsletter, then you probably have to provide that newsletter to that person every time. Where did the courts get this from? I don't know. It's not in the public records law, but the court said this is what's required. So if you don't comply with this, you're violating the public records law. So what sort of records are subject to this? They need to be, clearly articulated requests that, where you can understand what they're asking for. It needs to be an identifiable type of record that's regularly generated over time. So if you create press releases every Friday or about every Friday, and somebody asks for those Friday press releases, that's something you know what they're talking about. You regularly create it. That's something that's going to be subject to an ongoing request if the person wants it to be. Yes, this is a huge pain. No, I don't have any suggestions on how to better handle this. This is just the way it is according to the courts. What are the exceptions? I mentioned earlier that public records are presumed to be subject to disclosure unless an exception applies. There are 3 types of exceptions. The first is easy if it's made confidential by law. The second and third are similar, but they're not as easy. They're court-recognized balancing tests. They come from the common law, so they've just sort of been created by the courts over the years. And that's if there's a privacy interest or government interest. And I'll explain the details. As I mentioned, the first is super easy. If there's a law at the state level or at the federal level that says, do not give this out, then you do not give it out. But it has to be in law. You don't just get to make something confidential because you say it does. You don't just get to pull out the rubber confidential stamp and start randomly deciding what records are confidential. There needs to be an Arizona statute or an administrative code rule or a court decision or something similar at the federal level that makes the specific content of that record confidential. What are some examples of confidential records? Tax returns, FERPA protected education records, HIPAA protected medical records, vital records such as like birth certificates. That type of stuff is clearly made confidential by law. And even though it's a public record, you don't have to give it out because the law says you don't. Here's the problem with this. It would be in a perfect world in the public records law in Title 39 would be a list of all the things that are made confidential by law. But we don't live in a perfect world. So in all sorts of random places in Arizona and federal law, a statute will say, don't give this out, it's confidential. How do we know those? How do we know those are out there? Well, we don't. We're supposed to just be government employees who brush up on the law and somehow know everything. Luckily, the Attorney General in its agency handbook at the end of its public records law chapter has a handy table of, as far as it knows, all the Arizona laws that make different records confidential. So if you're ever wondering whether specifically the record you're looking at is confidential and not disclosable under the public records law, that's the best place to start. Check out that handbook chapter and the tables at the end. There are a few exemptions in Title 39 itself in the public records law for stuff that cannot be disclosed, that's protected by law. An example is the home address and telephone numbers of eligible persons. Eligible persons is basically police officers, law enforcement, judges, prosecutors, government officials who are in a tough spot where there will be people that will likely want to harm them. So their personal information, even though it's in public records and it is part of the public record, is protected and should not be disclosed. Additionally, there's protections for photographs of police officers in some situations. That way, if a criminal is upset about what a police officer did to them, they don't have a nice, easy shot of the police officer's face to go hunt them down with. If you basically intentionally give out this protected stuff about eligible persons and police officers with the intent to hurt that person or hinder an investigation, you're committing a felony. So if you say, I don't like that cop, I'm going to give out this photo to somebody and hope that it derails something or it gets that person's property damaged, you're committing a felony. So do not do that. Second exception to disclosure under the public records law is privacy. Privacy in Arizona is a constitutionally protected right. Not a lot of people realize that. So it's very, very valued by people in Arizona and the Arizona courts. So how does this work? It's a balancing test. Your agency, the agency that deals with the request, is the agency that makes this balance, this determination. So basically, would disclosure harm a privacy right that outweighs the public's right to the record? So on the one hand, so-and-so's privacy rights or privacy will be violated. On the other hand, the public's interest in that record. Which one is heavier? If the privacy damage is in your opinion more important or heavier, it weighs heavier than the public's right to that record, you can withhold that record on privacy grounds. A note, the courts have said embarrassment does not preclude disclosure. So embarrassment doesn't really factor into it, especially embarrassment of government employees. So if you've done something really stupid in your job and it's in your personnel file, just because it makes you feel ashamed doesn't mean you get to withhold that record on privacy grounds. What are some examples? I haven't really given you a lot of concrete stuff. Well, that's because the courts and the legislature haven't really given us anything concrete. There's only a couple cases that really flesh this out at all. Otherwise, it's very gray. So the first was concerning a 911 recording. There was a news entity that wanted to make a public records request from Mesa PD for a 911 recording. The agency said, no, privacy rights of the people in the 911 recording outweigh the government or the public's right to those records. The news entity sued and it went to court. The appeals court ended up agreeing with the government and said there was a child crying in the 911 tape and it was just a very emotionally wrenching thing. So they ruled that if this were disclosed, it might run on TV, it might be in the news, and it would repeatedly, stress out the family that was recorded in the 911 call. Meanwhile, the public interest in that 911 recording was especially low. Partially, I think, because in this case, the police department had already made a written transcript of the 911 call available. So there wasn't really much to be gained by the public from actually hearing the crying and the words. Meanwhile, it was going to harm the family. The second example was related to birthdays. A news entity made a public records request to the Scottsdale School District saying they wanted all this teacher information, including birth dates. The school district said, we'll give you most of it, but we're not giving you the birthdays. There's no reason for you to have those, and the teachers have a strong privacy interest in their own birthdays. The newspaper disagreed and sued, or maybe it was a radio station, I forget. News entity sued, and it went to eventually up to the appellate level of the courts. The court said teachers have a strong privacy interest in their birth dates, and there's a comparatively small public interest in those birthdays. Therefore, they don't have to give them out. So that, to me, is an important case because it makes it sound like personal information about government employees is probably something you can withhold on privacy grounds. Home address, home phone number, birthdays, stuff like that. Stuff that the public really doesn't have a good reason to want, whereas the government employees probably have a pretty strong interest in keeping private to themselves. Something that they gave to the government because they were forced to as part of their application, but that they really had no expectation would be given out to the public. The third exception is similar to the last one, but instead of a privacy interest, it's the government interest of the state. And it's basically calculated the same way. You, the agency, get to make the initial determination. Is there a government interest that's going to be damaged by disclosure? And if so, does that outweigh the collective public interest in the record? If it does, you can withhold the record. Fear of being sued does not factor into this. Just because you say you did something really stupid and you hurt somebody and it's in your records. You know you're going to be sued and probably lose. It's going to be expensive. That is not a good reason to withhold the record. That's the whole reason we have the public records law, so that the public can see when we screw up. So if you just think you're going to be sued over it, that doesn't really factor into this calculation. What do you consider? Well, the best interests of the people in their government, of how the government conducts its official duties. That's what you're looking at for the government interest. Is giving out this record going to harm your agency's ability to carry out its functions? You need to be able to specifically show a court, if you're challenged, how you would have been damaged by disclosure. So you can't just make up these general concepts of it will hurt us if we give out these records. You need to be able to say, if we give out this record, this is what is likely is going to happen that's going to hurt our agency in these ways. That's what you need to show. Because as you recall, public records are presumed to be subject to disclosure. The assumption is that's what happens. So you need to basically be able to flip that on its head by convincing a judge that a government interest would be so damaged that you need to withhold those records. How often does that really come up? It depends. What's a good example? In my brain, the prototypical example of this is when you have a police investigation. Say you have the sheriff's office is investigating a crime. They're working with the county attorney's office. They have some persons of interest who they suspect committed the crime, but they don't yet want to tip that person off because they're still collecting evidence and they don't want that person to flee. If somebody requests all those records, you probably don't need to give those out because it'll hurt your court case. It'll hurt your investigation. That's an example of something that would probably succeed on a government interest exception. So if you have records that have confidential information or information that's protected, what do you do? Well, you don't have to withhold the whole record. So if you have a 100-page document that has 1 page worth of confidential information, you don't withhold that whole record or you're going to get in trouble. Instead, redact the protected information. Get the black marker out, cover it up, and then photocopy it and give the copies to the person. You cannot charge fees for redacting information. From a practical perspective, it's best if you can separate confidential or protected information out from not protected information. But in some situations, that's easier said than done. So ideally, as best you can, keep those things separate so it doesn't become a pain and you don't have to redact stuff routinely. But you do have a duty. I want to make this clear. You do have a duty to redact confidential information. You can't just withhold the record because some of it's confidential, and you can't just give out legally protected information. So this is the middle ground where you redact the protected information. This is the slide, again, that I showed you earlier on, the proper analysis for handling a public records request. Is the requested record a public record? If not, you're done, don't give it out. If it is, it's presumed to be subject to disclosure unless one of those 3 exceptions applies. So then does an exception apply? If yes, don't give it out. If no, provide the record to the public. The public records law also allows or entitles the public to an index of withheld records when it's a state agency. So if I request records from DES and they withhold some records from me, I get to say, give me an index of what you withheld and why. But that doesn't apply to local agencies. So it doesn't apply to counties or municipalities. It also doesn't apply to the 4 exceptions at the state level on this slide. So you as a county are not required by law to provide an index of withheld records. However, I strongly suggest either doing it or doing something similar. So if you're going to withhold all the records or some of the requested records, I suggest telling them why and what records they are. Because if not, there's a good chance they're going to come to me and say, they're not giving me records and I don't think they have a good reason. Then I'm going to come to you and you're going to have to basically give me that same information. So it's probably better up front to tell the person, hey, we couldn't give you X, Y, Z because it's protected by this law or there's a privacy interest implicated. You don't have to put that in writing in an index, but from a practical perspective, I strongly suggest at least telling the person in some sort of official way. If you don't provide records fast enough, or if you deny a request and the person doesn't agree, what do they get to do? They can take you to Superior Court and file a special action and have it decided by a judge. It's worth remembering that if you don't respond promptly, it's the same to a judge as if you just deny the request outright. So basically, if somebody disagrees with how you handle a public records request, they can sue you, and then it's up to a judge. And then who the heck knows what a judge is going to say? A lot of the public records law is gray, and the public records law, everything sort of cheats toward disclosure, that the presumption is public records need to be disclosed. So you have a lot of burdens to overcome when defending what you've done. So what happens if somebody sues you over the public records law and your agency loses? Well, if the judge finds that they substantially prevail, you might have to pay costs and attorney's fees. So it can get very expensive. So if a court rules, yeah, you had no good reason not to give those records, or you took way too long, pay them some fees and pay their attorneys. And as you know, attorneys can get expensive, so this can get very pricey for the government. Again, Sheriff Joe, he's the prototypical example of this. He didn't have a good reason for denying records at one point, and the trial court dinged him for it, and then they got awarded, the requester got awarded $25,000 in fees. That's very expensive. That's probably part of what drove Sheriff Joe out of office, was that he kept racking up these massive legal fees. Something to keep in mind, you can't make something confidential on your own initiative for no solid legal reason. So don't promise confidentiality to somebody. If you have some person you're working with, or some company you're working with, and they say, hey, you're gonna keep this confidential, right? You probably can't say yes, because of the public records law. You can't make something confidential just because you promise it to a third party. So if you settle a lawsuit and they want confidentiality as part of the settlement, there's a good chance you won't be able to guarantee that confidentiality. If someone requests the record and you say, no, it's confidential, and then they sue you, a judge might rule that you have to give it out under the public records law. So better safe than sorry. Don't promise confidentiality when you're not sure whether you can deliver it. Something's only confidential if it's guaranteed confidential in law. Similarly, there was a court case on this where there was a notice of claim. So somebody was telling the school district they were going to sue them over a sexual assault. People wanted to see the records, but the agency had agreed to make those records confidential with a third party. And the court basically said, just because somebody wanted it to be confidential doesn't make it confidential by law. So that's the takeaway, is you can't just make something confidential. Be careful about email and confidential records. Once you send an email, you lose some control over it. So if it contains confidential information, you better be sure that whoever you're sending it to is not going to reveal that confidential information. Same thing with what you're using. Make sure be aware that your email is not necessarily encrypted, or that whatever computer you're using, especially if it's not governmental, might not be protected and encrypted, and people might be able to see what you're doing. Again, be careful about retaining stuff longer than you need to. If you're supposed to get rid of it after 5 years, get rid of it after 5 years. Be careful about putting public records on your personal computers and personal accounts. If you're doing business, official government business, on your personal computers and accounts, those are public records that are subject to disclosure under the public records law. So if somebody requests them, somebody from the government is going to have to go look at your computer and your accounts and find the public records, which means at least one person's probably going to see some of your personal stuff. So be careful about intermingling your personal and private stuff. What do you get to charge for? The public records law allows you to charge some fees in some situations when somebody wants public records. Specifically, the public records law allows you to charge for when somebody requests copies of public records. You do not get to charge when somebody wants to just come in and look at the public records. Under the public records law, the public has a right to inspect or to copies. Inspection basically means they get to come into your agency and just look at records. They can bring their camera or a little pocket scanner and scan to their heart's content. You don't get to charge them for that. But if they want copies, if they want photocopies or DVDs made, you get to charge copying fees. There's not a lot of guidance on this. The public records law provides almost no guidance directly in the statutes. It says you can charge a reasonable copy fees. The courts, there's one case from like 30, 40 years ago that addresses this a little bit, but otherwise it's very gray. So what do we know and what do we think we know? Well, you can probably, based on that court case, charge for the employee time spent making the copies, for the use of equipment and resources. So If it takes you 1,000 hours to make those copies, because there's tons and tons of pages, you can charge for 1,000 hours of employee time. If you use 10,000 pages of paper and 2 sets of toner, you can charge for that. You can't charge for the time you spend searching for the records. If it takes you 100 hours to go find all those records, that's something your agency is just going to have to eat. You can't charge for redacting the records. You can charge for postage if you're mailing the records. And that's about it. A common question I get almost weekly is, can we charge for electronic copies of records? There's nothing that says you can't. The public records law doesn't differentiate between hard copy and electronic copies, but you're going to have to be able to defend, if challenged, the basis for what you're charging. So if it takes you 30 seconds to email somebody a record, you probably shouldn't charge for it. Theoretically, you could charge for 30 seconds of employee time and I guess a few cents for the wear and tear on the computers and the electricity. But is it really worth it? Probably not. I know our agency, when it takes me a few minutes to email out a few records, we don't charge for them. If, on the other hand, somebody wants thousands and thousands of electronic records and you're going to have to put them on DVDs and it's going to take you hours to burn the DVDs, that's something you can charge for. The time spent burning the DVDs and the DVDs or the flash drives or the hard drives you're providing. It's something you should feel reasonably comfortable arguing in front of a judge if you get challenged. There are some records under the public records law that people are entitled to free copies of. The victims of certain crimes are entitled to a free copy of the police report. That's pretty much it. There's another one in the public records law, I think, that says if you're using the records in a lawsuit with the United States government, you're entitled to free copies of the records from the state of Arizona. And that's about it. It won't come up very often, but victims of certain crimes is probably the most common one that'll come up. They'll say, hey, my brother was murdered. I want a copy of the police report. You probably have to give it to them for free. So this has all been in the context, the fees have all been in the context of when the request is for a non-commercial purpose. However, things change a little bit if it's for a commercial purpose. So if somebody requests for a commercial purpose, you get to charge, I'll explain in a minute, a little bit more than you normally would, or even potentially a lot more. But what constitutes a commercial purpose? Basically, it's these 3 prongs here. If the person is going to use the public record to sell it or resell it, or if they're going to use the names and addresses in it to solicit for business, or they're going to sell the names or addresses to somebody else who's probably going to make money, that constitutes a commercial purpose. There's language that in the definition of commercial purpose that used to be interpreted by some people as saying any way you might conceivably make money, but the courts have said that's not what that means. It means just what's on this slide. These 3 things are the only things that constitute a commercial purpose. What are a couple things that the courts have said specifically don't count as commercial purposes? News gathering. So even though a newspaper might basically publish part of the record in their newspaper and make money from selling it, that doesn't count. News gathering does not count for whatever reason. Or if you're going to use the records in in furtherance of your business, for instance, if you're a consulting firm and by having all of these records, you're better at consulting, you're going to use them in your consulting, it doesn't count for whatever reason. Probably because you're not selling the information and you're not soliciting based on the information. So if you say, hey, is this for a commercial purpose? And the person says yes, what do you get to charge for? You get to charge for the same stuff you normally would if it's non-commercial. A reasonable fee for the cost of time in producing the records, the materials and equipment used to produce the copies, that type of stuff. But you also then get to charge for a portion of the cost to your public body for obtaining the record. So if your public body had to spend X amount of dollars to create or obtain that record, you can pass along a portion of that to the person. So if they're aerial photographs that cost $100,000 to produce, you can take a chunk of that and pass that along to the person requesting it. You can also charge them the value of the reproduction on the commercial market as you best determine. So if you know that the information they want goes for $100 a record on the commercial market, then you can basically charge them $100 per record. How do you determine that? I don't know. There's no guidance in the public records law, so you just need to do the best you can. Whatever you feel comfortable arguing if you get challenged in court. If somebody requests public records, do not get rid of those records. That should be obvious, I hope, to you, that you can't just delete them and then say, I don't have them, or you can't throw them in a shredder. Even if you realize, oh man, we should have destroyed those 2 years ago under the retention schedules. So say you were supposed to keep those records for 5 years and now you're 7 years in. Too bad, too late. You got to fulfill that public records request, and then when it's all done, you can then destroy those records. Same thing goes when you get a subpoena from court. If you get a court subpoena that says, hey, we need these records, or you get a litigation hold, for the love of anything holy to you, do not delete or destroy those records. You will get in a lot of trouble with the court. If you do it intentionally, you could be committing a felony. So that's why you need to be destroying records on time. Because if somebody requests a record that you properly destroyed years ago, you can say, hey, we destroyed those records pursuant to this retention schedule. Here's the form we filled out with Library and Archives that says we destroyed it. Then you're done. If, however, you didn't destroy those, you got to go dig them up and you got to provide them. Common question that I get from the government is, we get requests all the time from this person. They're a huge pain. We're pretty sure they're doing it just to be a pain. Can we just deny their request because they're a pain in the you-know-what? Can we take them to court? What can we do? The short, unfortunate answer is you pretty much can't do anything except treat them like you would anyone else and fulfill their request. There was a court case that got decided in 2011 where an elementary school district had a requester that they thought was just living to harass them with public records requests. So they proactively went to court and asked the judge to say to the requester, you can't make requests from us unless you first go to court and get permission. The court did not like that. Not only did they say absolutely not, they also dinged the school district and said, you have to pay that person's attorney's fees. So the moral of the story is, whenever somebody's a pain in the you-know-what to you, requesting records, too bad, so sad, you got to handle the request. It doesn't count as a public nuisance, doesn't count as harassment. You got to handle the public records request. There's one caveat to that. It's a question I get very regularly. Can we deny a request on the grounds that it's just too big or too cumbersome? The answer is yes. The courts have said you can deny a request on the grounds that it's unduly burdensome. So basically, fulfilling that request would eat up so many agency resources that it would inhibit your agency's ability to carry out your normal functions. So instead of policing or running the government of the county, we have to spend time and put our police officers on dealing with your records request. Then no, we don't have to handle that public records request. That's basically being made under a state interest exception. Basically, it's the state interest to deny this request because otherwise our functions will be harmed. The key with that, however, is it's very gray. There's not a lot of guidance for how to do that, and the person might sue you. So you need to feel relatively confident that if you're sued, you'll be able to convince the judge, here's why this is such a huge pain in the you-know-what. The person wants 1 million records. Every one of those needs to be reviewed. And they refuse to narrow it down when we ask them in good faith to narrow it down a little to make it more easy to digest. So if you get a really big, obnoxious request, I suggest being polite about it and asking the person, hey, this is going to be a huge burden on our agency, and it's either going to take months or years, or we're not even going to be able to do it potentially. So can you narrow it down? Can you give us a smaller time frame, or give us a better idea of what you're after so we can meet you halfway and get you what you need? If the person absolutely refuses, then you have more to show for yourself if they sue you and take you to court when you deny the request. So that's something to keep in mind. We have a whole bunch of additional resources on our website, including links to Library and Archives and their retention schedules. We have our Public Records Law Handbook and a whole bunch of other good stuff. So I suggest bookmarking some of that if this is your job, if you're a records custodian for your agency and You're the one who has to handle public records requests. Any questions?
Danny, we did not get any questions during the chat. If anyone has any questions, please feel free to fill out a question that you have in the chat tool.
Can I ask a question?
Sure.
My question has to do with if you're asking for clarification of a public records request and you ask them and within 2 weeks they don't respond. So you ask them again, you give them a deadline. Can you then deny the request if they never get back to you for the clarification?
If you genuinely don't know what they want, then I don't see why not. If you can't figure out based on the request exactly what records they're after and they refuse to clarify, then what else do they want from you?
Right. Okay. Thank you.
You're welcome. By the way, if it's tomorrow or the next day and a question pops into your head and you go, man, I wish I had asked that, our contact information is on our website, azoca.gov. Give us a call and ask for Danny, or shoot me an email, and I'll be happy to answer your question later. Or if you ever have a tough situation come up with a public records request that you want to talk to somebody about, that's what I'm here for.
Do we have any other questions?
My email address, I see there's a question, is dgarone@azoca.gov. I put it in the chat if you want to copy and paste it. It's D as in Danny, GARON as in Nancy, E @AZOC as in Charlie, A.gov. Well, otherwise, if there are no other questions, thank you so much for taking the time to listen to me today. I know it's weird for me to just talk into my computer, so it's probably weirder for you guys to just hear a voice telling you what to do through the computer. So thanks for being patient and bearing with me.
And Danny, we would just like to say thank you for facilitating the training today.
You're welcome.
I'm sure that we all have become more familiar with our statutory duties as it relates to public records requests.
You guys want me to send you a certificate like the last time, correct?
That is correct.
Okay, I will send that to you either today or tomorrow.
Okay, sounds great. Thank you.
Thank you. Have a great day, everybody.